Hey everyone, welcome back to the channel. In today's video, we're diving into one of the wildest encounters I've ever witnessed, where Judge Washington unleashes a savage takedown on a crayon-chomping sovereign citizen Karen. Trust me, this is one you won't want to miss.
There's something wrong with you. You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
So, a while ago, I covered this Neanderthal Karen, with her kids screaming in the background the whole time. Well, today, the kids are finally off to school, and now it's the mother's turn to get schooled by Judge Washington. Let's jump right into it.
Good morning. The 14B District Court is now in session. My name is Elaine Washington.
I find everyone's very funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anais Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anais Battle, appearing especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
well, that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
Well, if it walks like a duck and quacks like a duck, then it's probably a glue-sniffing sovereign citizen. As I mentioned in the last video, her argument is all about constructive eviction. Basically, if a landlord lets a property fall apart, the tenant can break the lease without penalty. But, as I pointed out before, She waived that right by choosing to stay in the property. Still, she's definitely a ducking.
Whatever you're using as your basis is still not correct. It is not the law.
It is. It's still under
It's
MCL
not
and it's under the Landlord-Tenant Act.
overruled.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because that's
rescinded or
not
not?
the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You cited a statute that I actually need to look at. MCL, what
I'm sorry?
what was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
I love it when they try to cite the law, thinking they've got it all figured out. But here's the thing. The lawyer is actually right. Under MCL 600.5716, the property manager has to file a demand for possession before the eviction process can even begin. So not only does she have no clue what she's talking about, but she also can't even read the law properly.
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody, please stop typing. It says a demand for possession or payment shall be in writing, addressed to the person in possession, and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question, though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession,
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate your objection.
Don't do drugs. Kids. because apparently they make you forget what you just said a minute and 58 seconds ago. So, let's hit the reset button and jog our memory for a moment.
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716. I just said MCL because they're both under MCLs. Both proof of service and certificate of service are both under MCL.
No,
All right, well, everybody, so let's not make my ruling.
Let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
okay,
is
answer that question.
not on the disposition. And just like she read on 657.16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
Object to what? I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next question.
And she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you objected me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because that is not the law, ma'am.
How is it? Okay. Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear. I said either federally funded or get federal funds, which you do if you accept Section 8 and.
Sure, that might apply to landlord eviction procedures for those receiving HUD assistance. But, as they're about to make clear on the record, this chemise isn't even on HUD. So whether she's living in a HUD property or not, those laws don't apply to her in the slightest.
No, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are, do you?
I'm not saying that. I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning
Well,
is,
it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a
Ms.
federal
Battle.
registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that
not a
these are
debate.
the
None.
requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing.
You're definitely being heard, but you're just too stubborn to realize why you're in the wrong. Here's the thing. The court isn't here to let your ignorance get you a free pass, especially not at the landlord's expense.
Move on.
Move on to, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If
Not-
I cannot have, this is not a fair hearing. And
No,
again, this is why
you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the
Please.
laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not, and I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
Please move
all
on.
of this is not right.
I'm telling you
And
now
attorney
that I'm going to be filing criminal proceedings against you for all these frivolous things that you're filing against me.
Whoa. Now that's rare. A judge outright tells someone they're facing criminal charges for running a bogus script, filing pointless federal court cases, and placing liens against her. And as a special bonus, because you know me and my team always deliver the full scoop, I've got an extra surprise for you at the end of the video.
If you feel that it's frivolous, that's fine, but it's not. My rights are not frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute
cross-examination.
If you're not going to ask appropriate questions, then I'm just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't have a real opportunity to ask the questions. So at this point, like I said, I'm just going to have to get the federal court involved and get the marshals, because I don't know what you all are going to do.
Of course, because this probably isn't your first attempt to scam your way into free rent. And now you're mentioning the marshals getting involved? Well, here's a reality check. It won't be the marshals, it'll be the sheriffs, and they'll be there to toss you out so the property can be repossessed. And this is the moment when Judge Washington finally has enough of her and makes it crystal clear how he feels about it.
You all have not been acting in honor and with good faith. So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you. I don't know what that is, but you should seek some mental help. Because something's wrong with you. You have a mental You have a mental problem.
I
If
have
you
a
think
mental
the
problem.
laws in
How?
the United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be
Anyway,
specific. No, be specific because
no,
now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
all right. I have
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action. And I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law.
Unopposed frivolous motion is still frivolous and holds no legal weight. So, whether you like it or not, that's exactly what they're saying. And I know some will argue that the judge should know exactly what to do. But the reality is, she knows exactly what to do. That's her way of nudging the complaining attorney to request a directed verdict.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is. It's
All right.
backed in case law. And y'all keep muting me. It's okay. Because he can talk, but I can't talk.
Ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so
okay.
what I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present defenses that are real, and she has refused to do that.
I didn't refuse to present defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the last piece.
Your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, you know, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the subject
We're
matter.
going down the same road.
Okay, listen, stop. I didn't cut you off. I didn't cut y'all off. You just asked me what my defense was. And
all right, I'm done.
wow. You're asking me what my defense is. I can't.
Take her out. I've asked her 3 times to stop this. All right, I'm going to grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes.
Thank you.
Thank you.
I'm sorry.
Thank you, Judge Washington.
I'm sorry you had to go through that.
All right, thank you.
Thanks.
Appreciate it. Bye.
Well, there you have it. Judge Washington ruled against her. And now this mother of the year has managed to make herself and her kids homeless. You'd think she'd put her children first before blindly trusting anyone on the internet. But no, she's a clueless Karen who only cares about one thing, herself. Now, as promised, I've got a treat for you. We dug through the federal court database and found the frivolous civil action she filed against Judge Washington, Magistrate Briley, and others. I'll drop a link to all the documents she filed, but for now, let's quickly go over a few of her most ridiculous claims. If you enjoyed the video, hit that like button. If not, feel free to hit dislike, but make sure to leave a comment below and subscribe with notifications on so you don't miss any of my content.